Good afternoon, everyone, and welcome. I'm really excited today to discuss privacy and new technologies, and in particular, how to evaluate the technologies. Various companies are constantly coming up with uh, brand new innovative technologies, and these are posing some significant challenges for privacy. Uh, what are those challenges? How do we identify those challenges? That role falls on privacy lawyers, both in-house counsel and outside counsel. So how is this to be done? How is this to be analyzed? And what makes this particularly challenging is that the legal landscape is evolving and changing incredibly rapidly. Not only is technology moving fast, but the law is moving fast. And in particular, a lot of the new state laws are requiring privacy impact assessments. And in particular, California is requiring one that actually has to go to the regulator, which I think is a rather new development. It's not just an internal document, but now it's something that has to get shared. So that adds new wrinkles and complexities to this whole endeavor. So I have with me today a really fascinating group of people to discuss this issue. First is David Keating, a partner at Alston and Bird in their privacy practice. I have Nameir Abbas, corporate counsel for privacy and product at Okta, and Ashley Massengale, assistant general counsel at Porsche, North America. So, welcome everybody. I'm really eager to chat with you about these issues. And I'd like to just start with the privacy impact assessment. I'm curious about your thoughts about, well, how do you do it? What's your process? What tips and techniques have you learned along the way as you've been doing them? And also, have you noticed any changes in what you do with PIAs over the years, especially in light of some of the new privacy laws? So I know that's a lot, and I'll just throw that out there and welcome thoughts on anybody from anyone.
You want to take this one, Nameir, or you want me to start?
I can kick it off. So I think that's a great question. And anytime I'm kind of in a position to kick off a privacy impact assessment, I like to just kind of set the stage and sort of feel for the edges of the issue, kind of what exactly are we dealing with? What is the business context? What are we doing current state? And then thinking through what exactly are we changing? And then the other piece of it is just from a logistical perspective, what is the business's proposed timeline, kind of who needs to provide input elsewhere in the business, who are the stakeholders, just thinking through the various inputs that will go into the privacy impact assessment aside from just the privacy legal aspects. I think that helps to sort of frame up what the analysis is and kind of how you go about it. And then from there, I think it's has to be a very fact-centered effort at the outset. You've got to understand what's coming in, what's going out, what exactly is the use case, how does all of that fit into what we're doing now and the broader compliance programs we have in place. And I think it's incumbent upon privacy legal representatives to really just ask questions and make sure you understand what is the meat of this technology, what is the point of this technology, because I think once you start to dig in, you oftentimes get details that are really relevant towards your downstream analysis and where you might land. And another thing it might do is it might reveal, well, at this stage, we're going to do this, but down the line, we want to do that. And I think, the sooner you can front end guardrails like, oh, you could do this, but you can't do that, I think that can help to kind of socialize those sorts of things with the business. So I'll hand it off to you, Ashley, for any.
Sure. I would just say that to use the term privacy impact assessment for what we were doing 5 years ago was a very, very generous characterization of what we were doing. And really, it wasn't until we started planning in 2019 for CCPA that we actually endeavored to really map all of our data practices, both in the technology space and otherwise. Only this year have we finally resolved to spend the money to have a software tool to help us do that and to have a much more formalized program, not just notes and files and checklists in a folder on the shared drive. So as the privacy laws are evolving, we've had to change and we've had to invest money, and we are still constantly trying to figure out how to get privacy impact assessments at an early stage in the development of a technology and not after it's already said and done and we're scrambling to make sure it's going to be okay. So it's going to be constantly evolving. It has since 2019 and it will continue to.
So, David, I have a question for you in all this, which is, as outside counsel, how much do you get involved in this process with clients for a privacy impact assessment? Are you ever called in to do one or participate with one or evaluate one?
Sure, and that depends on the client, on the maturity of the client's internal privacy operations. So there are companies where we will serve and we have attorneys who conduct PIAs for clients. And certainly when we're thinking about the GDPR at the DPIA stage, we're heavily involved. And then with others, it's more on a consultative basis. The idea of a PIA is still fairly new here in the States, not so much in Europe, longer history than leading to the DPIA under the GDPR in Europe. But in the States, right, we started to really see this concept come up probably, from my perspective, around 2010 with consent orders from the FTC involving certain companies. And they talked about this risk assessment process. So it took a while, right, as we saw among companies, especially those in the States that are not in regulated industries, privacy regulated industries, to move toward PIAs. And there were different steps that companies took, right? Like you might try to bootstrap on an ESA security risk assessment process so that it's not like you're adding new process, maybe less pushback, but you're working. The way Nameir kind of laid out the context, I just think such a really good way to approach this type of exercise. And one of the things you mentioned, and Ashley, I think you got to this too, I mean, it's a very fact-based exercise too. And that's really, you know, as attorneys and privacy professionals, non-attorney privacy professionals, really zeroing in on the facts, understanding the facts. You know, we can certainly talk more about that. That can be a challenge for a number of reasons with what we do. But that's ultimately what we're looking to reveal, the factual details that will allow us to then overlay policy and regulatory standards.
Have you noticed that a change in, and I think Ashley talked a little bit about this with her own company, that, you know, as the law increasingly is demanding that PIAs and DPIAs be done, are you noticing that there's a change in how robustly they're done, or how frequently, or kind of any trends that you see now that this is becoming increasingly a staple of privacy laws?
I would want to piggyback on something Ashley mentioned, which I think is a change, is that you're seeing more of a push towards automation and relying on technology rather than kind of workflows and checklist-based processes. And I think, you know, the case for that kind of spend and those kinds of resources is just going to become more robust. You know, we've got however many privacy laws passed in the US today. You've got increasingly complex guidance coming out from various jurisdictions. I think all those pieces are just going to help make the case for, we cannot be relying on kind of like one person's brain and one Word document, and we need like a solution that's durable and that people know is kind of the system of record for XYZ.
Quick follow-up. Have you found that there's a way to automate this that works really well, and how far can it get you to, something that is, robust, complete? Like how much can the automation help here, and what do you look to for the automation to do?
Yeah, that's a great question. And my answer to that would be, I think the tools are growing alongside us. And so I think we're in a position of, and a lot of privacy professionals are, of trying to build the ship while it's running. And I think the technology companies are definitely in the same position where they're trying to make their tools more useful, more kind of shovel ready, and at the same time trying to address an ever increasing scope of requirements. And, these tools also aren't one size fits all. Like some companies will have extremely different privacy needs from others, and I think that's another thing to keep in mind. One tool might work for one company, but not another.
I think that's right. Just to add to that, I mean, I think that we've done one of the things in the past that David mentioned, which is to include some privacy risk assessment questions in our IT security questionnaire that anybody has to go through when they've got a new, basically procurement relevant project. So a new vendor or a new project with a vendor. But as we all know, that doesn't catch everything and things come out of the woodwork. So we're hoping that this data mapping, setting up a cadence that we haven't figured out whether that's going to be quarterly or slightly less frequently than that, but that everybody's got to review and update and add anything that hasn't been previously mapped. We're hoping that that's going to be yet another tool to keep making this a living, breathing process within our company. And we are constantly looking for ways to get privacy ingrained at the very front of things. So that also includes training, communications, and other things like that.
So during this process, do you, use a technologist or consult with anybody? How do you do the impact assessment, especially when it involves some rather complex technology that might be hard to figure out exactly how it works?
So I can answer that probably with not a particularly helpful answer, but the most complex of our technology is in the car and it's developed in Germany. So to the extent that it has been assessed, it's been done by somebody else. My challenge is more getting my hands on that information, particularly in English, so that we can assess if there's anything we need to do on our end. But we have relied more in terms of outside help on outside counsel to just help us make sure that we're constantly flagging the things that we need to flag and keeping up with sometimes how to interpret the laws to our factual situation. So that would be one of my tips to everybody is if you don't already have a very active relationship with your counsel, you should get one, because I don't have David in my speed dial yet, but it might happen by the end of the year.
And just to jump in there, I think for us, it's a technology company and a lot of our experts are in-house. And so it's about understanding who you need to ask about a particular issue or question. Some things might affect multiple teams, right? And I think some of the complexity lies in understanding which issues are sort of discrete within one area and which affect a bunch of different areas. And, if it affects a bunch of different areas, it's incumbent upon us to sort of make sure that everybody's involved early on so that you're getting the right information, the best information in a timely way.
And there's art to that, right? Like that's part of bringing the kind of our legal skills to it, and certainly from privacy professionals, compliance, skills as well, at getting those facts and determining, whether we need to ask more questions, turn over more stones, whether we're getting the right answers, right? Whether people really know the facts underneath and how you interact with your internal clients to get details. And that can be hard, I think, at times for privacy attorneys and professionals where, just thinking of, the approach, like feeling it like you should know the answer, or feeling like the questions, maybe you're wearing on people's patience, but there's a way to kind of get through that. And it's really important to get through that to ensure that we're poking around a bit, hopefully not annoying our internal clients too much. It's not a deposition; it's a friendly interview, but just critical. Like you'll find, I think that sometimes if you're going to the product team, that team may not be that technical, or certainly some members of the team may not be that technical, and may have bad information, or may go to the vendor, and the vendor sales team or product team gives a response. It's just, I believe there's really an art to being persistent in a way that doesn't lose friends with your internal business clients.
Speaking of some of those challenges, I mean, especially what will happen if during the analysis you identify some problems. Let's say there's some serious concerns or problems. What do you do then? What happens at that point? How do you communicate the bad news, and what happens then?
You want to take that one, Ashley, or should I?
I'll take it quickly to say that thankfully I haven't had that happen to me yet. And I think, again, it would probably be something developed in Germany. So you've got to know who are the right allies and the right people in the conversation to go to quickly and bring everybody together to identify the problem. And we always try, not just in privacy, but across all of our work, to be very business friendly and solution based. So I think you've got to be ready to quickly say, not just no, but I've flagged this, and what are we going to do together to get around this? So thankfully it hasn't happened.
Yeah, totally agree with that outlook. And I think it's helpful to remind myself sometimes that the role is fundamentally advisory, and what we do is we advise on risk. And so describing the risk in an explain it like I'm five way can often get people on board with starting to solution the problem, whatever it may be. Oftentimes, I agree with Ashley. It's often more things that we want to do to influence something and not just put a stop to it. It's more about how can we make this better? What can we do to work around the risk, to prevent the risk? Those sorts of answers. And I think when you communicate it that way, and when you've got good business partners who kind of understand where you're coming from, that goes a long way towards bringing things to a resolution.
And that highlights the importance to work with your internal clients, or as outside counsel with your outside clients, right? In terms of building those relationships, your credibility within the business, and that the element of not just compliance, advisory, right? Stewardship, shared objectives, and that I think can really help. Plus, in today's world, there's just broader awareness. It's in some ways simpler, easier than it was 15 years ago, especially here in the U.S. to talk about these issues.
Now, if I'm not mistaken, I believe that the CCPA is going to make a really significant change in how PIAs are ultimately disseminated. Because for a lot of laws, it's just something that you need to do, but that no one really outside the company sees. So it's kind of really just an internal hygiene practice. But I believe, if I'm not mistaken, that the California law would require that the PIAs be available to be looked at or even filed with the regulatory agency. So this is a little bit of a game changer, because what is internal now is going to be looked at by folks outside. And so I'm wondering, what happens? Does this change things if this document prepared only for internal uses is now external? What's the thoughts or strategy on how to respond to that, or has it even been approach? Would it be approached a little differently? Because would you want to show it to outside counsel now? Because that does really change the risk equation, I think, for creating this document.
So, a couple of thoughts I can add, and you guys may have some others, right? But that's been the case for a while in Europe. Companies that are subject to the GDPR know that with the DPIA, for example, there could be a requirement. First of all, with the DPIA, you're involving a putatively independent entity with the DPO, and the DPO may need to coordinate with supervisory authorities potentially, right? So you have that, and that in Europe combined with the different ways that the privilege applies, that creates challenge and be thoughtful in that process. As a result, here in the States, I mean, we're seeing in California the rulemaking process unfold. We're not quite sure yet exactly what the standard will be, but one thing is you may have this exercise look a bit like the forensic investigation process in a data breach, or particularly like a payment card breach where you have a mandatory, PCI-driven investigator, and then you may have a separate parallel privileged investigation. It may seem something like that start to develop in the States. That's more resource intensive, not as efficient. But there could be cases where that's important for privilege purposes.
I would just say that we haven't really begun to prepare for that at all, other than just really being focused on our system. And if a regulator comes in, we know how we're going to produce this and show this. It's not just a bunch of haphazard notes and files everywhere. So we haven't really thought about the content of it yet. And we have had some conversations about when we flag a risk, do we want to create that in the software tool? Do we want to take that outside of the software tool? What are those implications? And haven't made any decisions yet on that, but just to sort of flag those kinds of things that you've got to think through. What are the various places that you're documenting a risk, particularly if you didn't mitigate it and it results in a breach? So.
Yeah, and I'd just echo that and add, similar to what David said, that just very interested to see where all of that lands. I think it's tough with the rulemaking coming now and, however many months until things become effective. So just important to keep your ear to the ground, I suppose.
Yeah, I think there's a really interesting policy question about this too, which is that, on the one hand, you could say that, by making these more accessible to regulators, you are creating more accountability. And the PIA is not just some, paper that can be thrown into a drawer or just done, on a kind of just a pro forma basis where, okay, I did my PIA and fine, but it doesn't really, have any impact. It really will, hold, a company accountable for how it does the PIA and how it responds to any risks identified. So we could say that's good development. On the flip side, it could lead to more caution and less candor doing the PIAs. That if this is where the something where the regulator is going to be looking at it, identifying a risk now comes with an exposure to the company, because if you identify a risk and then it's not adequately addressed or it becomes really a difficult choice for the company. It then creates an exposure because it's not going to look good to the regulators if all these risks are identified and then not addressed. So that might give you maybe a little more caution about putting that in the document, because you're essentially laying forth a whole bunch of things that you would have to address, and that could potentially be flagged by a regulator. So it could lead to maybe less candor in this process, or to more things kind of going outside the PIA, just being told to people, by the way, let's kind of fix this now, and then I'll do a new PIA, I guess. I don't know. I wonder what effect this is going to have, and if it's ultimately going to lead to something better or something perhaps worse.
Yeah, I think that's a really interesting point, and I've never quite thought about it like that. But hearing you frame it like that kind of brings up an interesting tension with some of the earlier points that were raised about the importance of this being a fact-intensive inquiry, right? I mean, I think when you think of fact-intensive, you want people to openly air details regarding what's going on, and there is a tension between doing that and the sort of collaborative efforts that flow from there, and reducing something to a piece of paper that might be disclosable as part of some sort of inquiry. So I think it's all very interesting questions, and it again points to kind of how new a lot of these requirements are, that still sort of people are thinking through the tradecraft still.
Yeah, it also popped in my head, this idea that who's completing the PIA and how is it completed, right? So we might be using an online tool that our business owner completes, but now I'm thinking, should they be completing a preliminary document, but only a lawyer creates the PIA itself that gets filed so that it's lawyered properly to disclose just enough and not enough information? I could see that kind of process change, not relying upon your business people to provide the information directly into it.
The candor issue is interesting, right? It is with whether that potentially chills the fact discovery exercise. I mean, I think there are ways to structure that, but it is really a question on the accountability side. That's a good point, right? I'd say that even without production of PIAs or DPIAs to the regulator, there's also accountability for Privacy Counsel. That's fundamental in that if you get it wrong, it's not good for you. Like, in other words, there's that the PIA has to be right. Your advice has to be right, has to be comprehensive, or you're accountable as a professional. The one other thing too is that two things. Here in the States, my view is that the PIA process and the content, the analytical process and model, is more mechanical than what we have in Europe, than what's under the GDPR. Whereas in the GDPR, we're expressly contemplating factors around the fundamental privacy rights of the data subject. Generally, that's not an element of what, it's not one of the components, right? We're measuring that here in the States, just generally not. We're more looking at factual, regulatory, contractual commitments, notices, things of that nature. So I note that, how that might play in a little bit. The other is how you wrestle with the gray zones in the law, because there are a lot of gray zones, and that how you do that, how the kind of risk quantification process happens could change based on whether there's this requirement to produce.
Yeah, I think there's some really interesting challenges ahead for how this gets shaped, because what the PIA has these dual functions. It's both an accountability mechanism, but it's also kind of like an internal review process, and they align sometimes, but those goals are actually in tension in other times. And then how this evolves is going to be interesting. Just how lawyered do these documents actually become, versus how much are they just really a tool internally for to just ferret out issues and really identify problems, or they really just something papered over after the fact. So it'd be interesting to see how this evolves. I was curious, more generally, what are some strategies that you use to get more buy-in from upper management, to try to leverage the developments in privacy law to get more resources and ultimately, more cooperation with teams and others in the company. How do you strengthen the overall position of the Privacy Office, Privacy Counsel?
I can jump in on that one to start. I think one helpful aspect of this is that privacy laws are, they can't get put in a box. There's a lot of public touch points. You have to have notices. You might have to have certain contractual provisions in place. You have to respond to data subject requests. And so there are all these various components where, in a sense, the privacy function is representing the company in a way publicly. And so I think if you point to the various ways in which that emphasizes or places pressure on the need for resources to make sure everything is properly supported, that's a helpful talking point. And I think the other one is just the general rising tide and heightened expectations, I think are becoming clearer to people in the business. I would think 3 years ago it was more like, what is GDPR? And now everybody knows about GDPR, and also that there are these US state laws that are being passed in an increasing number of states. So I think that's another kind of feather in the cap. And then the third thing is just pointing to, you want a durable solution in place, and that requires building a strong foundation that's replicable. And so you need some investment up front to do that. Like any other product, the privacy program in some ways is a product, and it produces an output of compliance. So,
yeah, I would agree with that. I think that the ever-changing legal landscape, one of the only pros that I see in it is really that it has helped us to make an argument that we need more resources. And it's easier at our company to get money than it is to get people. But to really build out budgets of this is what we need to be able to continue to keep this company in compliance with law, and here's all the reasons why, it actually hasn't been that hard of a sell. But I think anytime you're in-house, you have to be strategic. So we can't do that every year. We can't wave the flag every year and say, look, more privacy. We did it on a large scale in 2019 to get money for CCPA. And then we tried to be as lean as possible until this year we said, look, we need another budget for 2022 to get ready. And then also looking for partners around the company that might also be able to make budget and staffing requests to support you. So for instance, our IT department, we've been saying for years, we really would like to get a tool to make this happen. They've been pushing that request to the powers that be, and we've finally gotten to the point where we've gotten that tool. And interesting, as they plan for 2023, they came to us just this week to talk about their budget request, and there's different categories of requests they can make that might affect their approvals. And one of them is it's legally required. And it's very rare that some sort of IT system or software is legally required, but we've been broadening that definition by basically together arguing we can't possibly comply without this tool to do so. So I think it's being judicious about your waving the flag and screaming for resources, only doing it when it's really necessary, and partnering with others across the business.
How do you deal with the challenge that privacy compliance might be viewed as a cost center, as a drag on innovation? That basically this is something that, oh, well, we have to do it. The law makes us do it. And it's just going to be seen by upper management as a cost, the cost of doing business and an increasing, growing cost as we have more laws versus, something that is less in tension with, the company's, growth and profit and innovation. Is there a way to make the case that, privacy is more than just avoiding, some bad regulatory outcome?
I think we're lucky at Porsche that globally, and particularly being a German company, we do take privacy seriously, and we have sort of strategic goals. Our company globally has just gone through a new set of goals, and privacy and the needs and expectations of the consumer at the forefront of those strategic goals. So like anything in legal and privacy space, I mean, we are a cost center. And when you try to make arguments like, look at the potential penalties if we were to have a breach under CCPA, they're just too far away to override that cost center attitude. But I think by being good business partners, and like we talked about earlier, always using your position to help the business figure out how to do something rather than preventing them from doing something is key to combating that impression.
Yeah, completely agree. I think the key there is, like Ashley said, partnership. I mean, the business is a stakeholder in its own compliance. And so making sure, it's their product, it's their functionality, their area. And so kind of forming a partnership with them and emphasizing how, privacy compliance is just a feature of what's going on, of what they're doing is really helpful. But I also agree. I mean, on some level, it is legal, it is privacy. And so you want to stay focused on kind of the concrete asks and not get too in the clouds, I suppose.
So
I think, Dan, I can just add real quick too. I think that does highlight like the way I see to the tool, to acquire that business support with companies like Okta and Porsche also that are known for their work in privacy. That highlights the brand impact and the positive brand impact that's there. And that gets to the stewardship piece, right? Which I think is taking that internal privacy role to that next step, subject to Nameir's caution about, getting to, kind of beyond the nuts and bolts of what needs to happen. It is an important component combined with, we certainly saw with the GDPR and the 4% global turnover potential penalty that really caught the attention, particularly at public company level of companies. Noting that here in the States, when we look at the statutory fines that are set up, there's no 4% cap. It can go beyond, but still that, that really caught the attention of the business community.
So broadening out our conversation, I'm curious, in particular, what general trends have you seen that involve privacy and innovation and new technology over the last few years, and kind of looking into the future? Are there particular issues that you think are of the most concern? Kind of like, where do you have your eye on the evolving landscape here, as far as what issues do you find most challenging to grapple with? What issues do you see in the future that are ones that you're are likely to be on the horizon?
One thing that I'm concerned about is the increasing shift from more of an opt-in than an opt-out culture of privacy. It's not always, especially with all of the data collection that is possible in a vehicle, it's not ingrained in us to always ask for permission first, and to make sure that every touch point where we might be collecting geolocation information, we've got to identify every single one and figure out how to build in that consent. And so it's those kinds of trends about giving consumers more rights creates a lot of challenge from a technology standpoint for us.
Yeah, and I think one big thing from my perspective is just, we've talked at length about all the new U.S. state laws, but that's a kind of a trend that's being replicated across the world. And I think it's the interplay between those laws and how that affects, like, if you've got customers, what their expectations are for how you approach privacy compliance. I think that sort of interplay is just becoming a lot more complicated as people get a lot more sophisticated, and frankly, as countries pass laws but provide very little guidance, or maybe don't fill certain gaps right away. And so you're sort of in this position where David mentioned gray areas earlier, where you are kind of trying to figure out what are the gray areas and when are they going to be addressed, and how can I come out with a strong compliance position now that can kind of withstand a shift in the winds, if you will.
Yeah, some really interesting points there. I mean, on Ashley's point, I recently wrote an article called "The Limitations of Privacy Rights," where I argue that a lot of the privacy rights are over relied upon by the laws, that people really struggle to manage their privacy and really don't have time to do it for all the companies that have their information. It doesn't scale very well. And also, people really don't have the expertise to make a lot of these choices, but they're constantly being asked to consent to this or that. I was recently on a vacation in the EU, and the amount of cookie notices I got was oppressive. Just constantly asking me, do you want our cookies? Do you want our cookies? Do you want our cookies? And I just click yes, because just go away. Otherwise, I get a screen that gives me a choice of more types of cookies than there are flavors of gelato. I was in Italy. And I don't have time to go through and figure out what each of these cookies does and what it is and check and uncheck the box. Otherwise, it'd take me all day just to do one site. So they're getting my consent, but it's not very meaningful. And it's not really clear. I'm actually not consenting. I'm just saying, go away. So there's a problem with that. On the other hand, if you don't, ask people what they want, then, it becomes trickier. Who decides what people should get or not? So the law is really, I think, struggling with this because I don't think it has a good answer to, consent. Can't live with it, really can't live without it. So I think that's definitely going to be an issue that we're going to face in the future, because I'm not sure that, it's a desirable situation or even very feasible to get meaningful consent for everything. I also don't think the notice and choice approach of the US, the opt-out approach, is very meaningful either. The fact that someone doesn't do anything doesn't mean they consent to things. So really interesting issue. And I think, it's going to be an issue we're going to struggle with for a long time. One thing about the changing legal landscape is, how do you keep up with it? What, do you have strategies or what do you do? Because ultimately, if you really want to keep up with it, you really can't have a personal life. You have to read all the time. How are you going? So what do you do? And any tips for how to keep up with everything worldwide?
I know I subscribe to some newsletters and blog posts from some of the people on this webinar. And then, I try to set aside a little time every week just to read up. And it's not a perfect approach, but I do think, setting aside like a 30-minute window on Friday to look back a week and see kind of what's happened is really helpful. And the other thing I do is I do try to, when questions come up just in the course of work, I try to read up on them and then read a little past them. And then I also try to kind of keep track of, just keep a running document with certain details I found. And that way, if a question comes up, if you remember, oh, I read about this a couple months ago, you at least have something that you can kind of refer back to as a starting point. So, but definitely not a perfect art. So if anybody else has something better.
No, I would echo all of that. We, try to subscribe to newsletters and alerts and bulletins. And we certainly, as mentioned before, I recommend building a good relationship with counsel so that they are going to also be thinking of you when something new happens that you need to consider. We had an employee survey, and one of the questions was, I have enough time and resources to do my job. And I think of Nameir setting aside time each week to read up on things. And I even calendar that time, and then I just move it to another day and move it to another time and keep going as work gets in the way. So it's challenging. We have the privacy team in Germany gets a quarterly update from outside counsel of what's going on in privacy laws around the world. So if you have the money and the resources to pay someone to have a formal system of updating you, that's another option as well.
There are a lot of free resources out there, certainly, and it's, I think, advisable we do it and we have our team do it subscribe to different resources. And then there are some good, subscription services as well. I will say we like Bloomberg BNA, their privacy and security report. It's a good resource, but there are many others, whether you're looking here in the States, in Europe, elsewhere. So that's one real helpful way. It is tough though, right? In the last week, 10 days or so, 12 days, whatever, we've had a lot of new reading material in California and coming off the hill.
Yeah, it's really challenging. In other fields, in property, you don't have to go and check back to see is the rule against perpetuity still the law, or in criminal law, you don't have to go back and check, well, is murder still the same? But in privacy, every week it's suddenly like the law is completely different, and everything has changed, and there's a whole bunch of new laws. So it's incredibly challenging. And I agree with David. There's so many good free sources, but it's like there's too many good free sources. And I think they're all, a lot of them are pretty good, but there's so much stuff to know. And that's my job. I mean, I have the time to spend reading all the time, but I can't imagine how hard it is if a lot of your job is actually implementing things and doing the day-to-day things that a business needs, and then on top of that, looking at how the ground is constantly shifting, which actually raises another question, which is, and I think that we see this in privacy impact assessments and just generally, and that is we have all the different laws around the world, and they have different standards, even different standards for what goes into a PIA or DPIA. And so as we have the different standards, how do you try to figure out what to do? I presume you do one PIA for each technology or product. So how do you do that when they're not all the same, and the requirements aren't all identical? So, and that generally goes for a lot of law. Like, how do you comply when you have the different standards? Do you just use the strictest one? Do you try to, look at all of them and then try to, mash them together into a synthesis that would pull the toughest things from each one? How do you deal with that issue of complexity?
I think that's rightfully sounds very complicated when you're actually developing technology and you may not be able to accommodate everything. I don't really run across that. I mean, we're just trying to figure it in terms of our data subject rights request process across the state. So I can only imagine if it's difficult to do that, how difficult it must be when you're building an actual technology. So Nameir might know more about that than I do, but thankfully that hasn't been my problem yet.
Yeah, I mean, it's with great complexity, I think. But I do think, the default approach is probably go for the strictest standard to start out, and kind of going against that standard, figure out if there are reasons, business reasons, technological reasons, why in certain scenarios you might not need to hit the strictest standard, but you can meet some specific standard. But I think if the expectation is that the laws are going to continue to get more strict, then you might as well go with the strict approach now, and so you don't have to revisit anything down the line. Then if there's some big cost or some concern with that strict approach, that's, I think, where you might step down a little bit. But easier to start high than go low, I think.
Yeah, I'm thinking about this in particular with sensitive data, because the laws, are somewhat vague about what the specific issues you need to do for a PIA are. But one of the triggers for a PIA is sensitive data under some of the laws. But each law has a different set of things that are sensitive data. And then we deal with the whole inferences problem, which is sensitive data is open-ended. It could be anything giving rise to an inference about something. So figuring out, like, okay, when do you actually need to do this becomes a challenge, because that differs a lot in laws. So, do you just do one for everything? Do you, how do you figure that out? Because it depending on how a law defines sensitive data and when the PIA is triggered, it might vary a lot. That's why I see some of the most variation in the law.
On the flip side, just to piggyback so somebody with more knowledge and expertise can answer, but it's also kind of the flip side. If you have a technology and there's just one jurisdiction that requires something different, but you're not technically able to build something that can only, fit that one jurisdiction, what do you do? And I would say in the car space, we have to make a decision on things like if there's one state that requires something and the rest of the world doesn't, and it's a huge burden, maybe we don't sell cars in Massachusetts or, just to pick a state out there. So it's a challenge on both sides, dealing with competing laws and then dealing with one-offs that maybe it's not that easy to do.
Yeah, well, car data is a lot. Geolocation is sensitive data in a number of states now. So we're putting it into the strictest category, which I would presume implicates cars.
I think that I would say too that if the question is like what triggers the PIA or the DPIA. Let's say here in the U.S., the PIA, one view is that, you consider and look at a PIA whenever you have a new processing of personal data or some material modification to how you process personal data, and that may be your threshold. Next step, then you step into like the Virginia DPA category, and how do you hit that threshold, right? So, but I think at the starting point, there's an assessment that you may have that baseline standard. Looking across complexity too, just from having laws that are different standards in multiple jurisdictions, Nameir talked about potentially starting from that most strict standard and working back. And there can be a balancing with the value from simplicity in operations. And maybe that's compelling enough to say, we're going to have a national standard or we're going to have a global standard based on, this time period, based on this definition of sensitive data. On the other hand, when we bring together multi-jurisdictional analyses for clients, looking at like a new product or a new initiative, we do try to, but also make recommendations around when you might have non-uniform approaches in certain jurisdictions, right? So there's an element of it that's just really blocking and tackling and then making those judgment calls.
Final thoughts. We're nearing the end of the hour. I think it's been a really fascinating discussion, and it really shows just how challenging the role is for a privacy lawyer to navigate all this. Both having to understand and deal with technology, which is changing very quickly, and the legal landscape, which is growing and changing, and also has multiple different standards as well. Trying to navigate this it takes a strategy, really, because there really isn't a clear one size fits all playbook for how to do these things. So does anyone have any further thoughts before we wind up?
I would just say, I think that while it's challenging and it can be stressful at times, it's also what's fun about our job. And especially if you've been in a job for a long time, to have these changes and have these new challenges and new intellectual stimulations is really rewarding. So I have a love-hate relationship with all of this.
Yeah, I'd agree with that. I think it is on some level cool that we're dealing with like a lot of novel questions on a regular basis. It also makes the job hard because sometimes, everybody wants a quick yes or no, but it's like more of a yes, but, or a no way or something like that. But it is kind of rewarding to kind of stumble on a solution that works for everybody. So that's why I think it's important go for that collaborative spirit.
I think that sort of perspective is awesome. Like I'll say to, attorneys at times who do what we do, when someone asks you what sort of law you practice, and you say to them, privacy, and I do cyber. I mean, the answer is, wow, that's really neat. It must be really interesting. So thinking about it from that standpoint, I think helps. And then building those relationships internally, building that credibility certainly makes the job easier, smoother.
Well, absolutely. I agree with everything that you all have said. I think it's a really fascinating, interesting, wonderful field. It's so exciting to see new things happen. As a professor, that's really neat to constantly have something going on and changing. The only time it gets to be a little bit onerous is when it comes time to update my case books and treatises. Then it's a lot of work. And I look over with a lot of envy to professors in other fields who basically only have to change a few sentences in theirs, where I have to change practically a third of mine each time, every few years. But it's a good problem to have because things could be rather slow and boring. Anyway, thank you to all of you for joining me today for this really interesting conversation. And to everybody, have a great rest of the afternoon.
Thank you.